Good evening, ladies and gentlemen. I thought my session was at 4. I think it's dot 4. It's very seldomly that you have a session at the dot time. I think we are just before time, maybe 1 or 2 minutes before. Anyways, it's a nice thing. First and foremost, I thank Dr. Deepak Sahu for arranging such a wonderful a conference and on a more apt topic in the present circumstances. In fact, what I shall be addressing to you is basically on a live investigation related to the corporate frauds, data frauds. In fact, for the past 15 to 16 years, I worked with various law enforcement agencies, with the various judicial agencies. And one of the cases which just struck me around, just about a couple of months before, I had one very interesting case, and I thought that I should share with you on this forum to make you aware that emails can be as expensive as 450 crore rupees. That may sound very surprising. Well, that's the situation. Well, before I touch upon the case and tell you exactly what happened in a multinational organization, just let me give you some of the, curtain raiser. I'm sure that in the last decade, there was a huge spurge of cybercrime. COVID is still not over, but in the last couple of years, we have seen that the advent of the crimes have increased exponentially, and that's some of the statistics what's been there across. Well, the banking frauds, just don't take it from a political perspective, please, because there are some political agencies that doesn't mean it's from a political perspective. So, because the digital crimes have increased because we are now become more digital. And if you see across, we have about 3,367 banking frauds way back in 2007, 2008, way back going to about 83,638. That has significantly happened simply because we are using more digital technology. And that's the reason that the graph, which has grown exponentially from 2016 to 2021, there is a sharp upsurge. Well, when we talk about the corporate fraud, it's not a new phenomenon. It's been going on for years, but in the past 2 to 3 years, there is a significant amount of increase. Well, most of the industries today which I come across are dealing with data theft, intellectual property rights, and ransomware. These are some of few of them. But all this, I think you might have heard, you might have listened, or you might have been a part of that particular process. But then, what I'm sharing with you, if you see it across, according to one survey conducted by the Economic Intelligence Unit, published in Business Today, India has one of the highest percentage of companies where fraud, in particular corruption, bribery, corporate frauds and scams, so on and so forth. We have seen Satyam fraud whatsoever. Well, the types of corporate frauds, I'm sure that you may be aware of this, but one of them I'm going to touch upon today in today's session. Key findings of the DLH Survey 2022, fraud schemes most likely to be experienced in the future, 19% cybercrime, around 13% that is vendor business partner favoritism, almost about 12% that's about the bribery and corruptions. Well, going ahead, top 3 changes required for better fraud risk management, 22% is technology investment towards an enterprise view of fraud, 16.5% enhanced third-party due diligence, which is very important. I happen to do some due diligence of banks, and when I go to the banks, most of them do tell me that they have got the best systems in place, they have got the best compliance in place, but in reality, when you do a due diligence, you find that there is only a small percentage of which is there, the larger percentage of it is missing around. Well, about 16.5% greater employee awareness to fraud. Over 50% of corporates indicated they would prefer to take legal action against parties involved in fraud. Well, that's a huge percentage. Way back 16 years before, when I started investigation or when I came into the field, this was in single digit. Around 2 to 3% would like to take action against the employees or action against the party who has initiated the fraud. Well, that's the interesting part. A corporate data fraud worth 450 crores, where an email played a significant role. You'd be very surprised to know that how come an email could play a very significant role in a corporate fraud worth 450 crores. Probably the first case in our country where at least I dealt across with. Well, I'm just giving the so-called, the anecdotes as company A and B. Well, company A and B collaborated to form a private limited company as company C. And company C had 5 directors, of which 3 were from company B and 2 were from company A. Well, company A happened to be the investor as well as one of the stakeholder in the management of the organization. Company B was actually the process-oriented company. When I say a process-oriented company, it means that this organization had the knowledge base where the investment which would come from company A would be used by the company B and the profits would be shared according to the proportion which was made in the agreement. During the board of directors meeting, a resolution was adopted stating that an independent management team should be selected and that company A would not be held liable for any project delays. Furthermore, the company A mentioned that any delay would result in an extension in the loan repayment to the company B. It's very clear. This point is very critical to the point that how the company A later on made an allegation against company B for the delay of the project. And that delay of the project would cost company B about 450 crores. Post the board meeting, due to delay in the project, company A was served with a legal notice for repayment of the debt to the sum of rupees 450 crores, which included the principal amount, interest, opportunity cost. As a result of receiving an unreasonable notice, the company filed a civil suit against company B. Well, that's something which is very simple, very clear. So the company A went against company B, filed a civil suit saying that the investment what they gave was not properly utilized by company B and the total damages what they claimed across was about 450 crores from company B. And that's why company B went for an appeal, filed a civil suit and said that it's an injustice against them. Well, that's something very interesting. Well, all these CIOs who are over here, all my friends who are from the same fraternity, what I come from here are over here. Well, the most important significant in this case was that company B wanted to prove that company A was not only involved in making an investment, but also played an active role in the management of the company. And that's the reason that when the civil suit was filed, company B put a petition in the court asking that the emails which were being percolated from the official domain of the company to be put on record in the court, because these official emails would then give the indication that it is A and B together were running the management of the company and A just was not an investor in the company. But then it was found that when company B, when they filed an application, they found that company A had deleted the emails. Let me tell you, the deletion of any emails or for that matter, any type of distortion of information, deletion, modification of data amounts to a cybercrime. And therefore, when they noticed that there were some emails which have been deleted, they made a criminal complaint. Now, I am over here to put to you both the side of the stories. I am sure that most of my friends who are there from the corporate world would not like to take the matter to the law enforcement agency unless and until the matter is of such prime importance and significance. So, when a criminal complaint was filed, the data was deleted, emails were deleted, the police were given a piece of an evidence. You see, when you talk about the Google workspace, when the analysis was done by the company B for the emails of the company A, they found that there were some emails which have been deleted, which was something about 2,000 odd emails which have been deleted. And that's the piece of evidence what they gave to the police, to the law enforcement agency. The police filed the FIR, but during the investigation they found that the complaint which was made by the company B against company A was frivolous. And therefore, instead of filing a charge sheet, they filed a final report or a summary report that's called as B summary report, which meant that the charges were frivolous, the complaint was fake, and therefore, the company B should be prosecuted. That's what it was being made. This case came to me for my opinion. Well, it's very interesting to note that when the emails were there, the client was Outlook Express, the email client. What happened during the investigation was some shortcomings. Well, all the shortcomings I would not like to put it in front, but in some of this part, surely I would like to put it up over here. Some of the part I would like to put it up over here, and that's over here. Well, when the laptops of the accused was seized, you know, when we talk about Google space, it is G Suite. So, the accused laptops had the files in the Outlook Express or the Outlook, and those files were basically called as the mbox. Now, these files, they were being compared with G Suite. Let me tell you, the accused had deleted significant emails which stands as a primary evidence in the court from the G Suite. But then, the OST and the PST files which were being available from the laptop of the accused, that served as a primary source to make a comparison between the G Suite of the accused and the OST and the PST files of the accused. Let me tell you, during this analysis we found that there were large number of emails which were deleted. Why I meant to tell you this is because when the investigation was completed, nobody thought about that one significant claim of finding out whether the emails were deleted or not would come from the OST and the PST files. We normally have a look only at the G Suite. If the emails are deleted from the G Suite, we conclude that these emails cannot be recovered, although there is a procedure. Up to 55 days, emails still could be recovered even though they have been deleted from the G Suite. But let me tell you, the time of the complaint which was being made and the data which was to be recovered was more than 55 days. Therefore, Google also took his hands up, said that, sorry, we cannot do anything. But the OST and the PST files which were there in the accused laptop played a very significant role, and there we found the differences between the G suite as well as the OST and the PST files, and we found that there were emails which were being deleted, which was not found in the investigation by the law enforcement agency. Why I mean to tell you is because it is not expected that the law enforcement agency would know each and every technicality of the matter. I think tomorrow, if this situation happens in your office, if it happens in your industry, and if email is a part of a debate, which was a part of the debate over here, to prove that if these emails were retrieved, it would prove the onus that A and B were playing an similar type of the role in the controlling or the management of the company. And that's how we found the deleted mails which were present in the Outlook file, which were not present in the Google takeout file or in the Google workspace. Well, while comparing the emails from the Google takeout file of X person with a Google takeout file of Y person, it was found that emails were missing. Let me tell you, this report is now in the court, but a matter which was bound to be closed, a matter which was found that okay, there is no evidence to prove that the emails are deleted, there were significant emails which were still recovered, and now in the court, what I mean to say is that electronic evidence cannot get diminished. We may try our level best, we may try all types of formatting, low level, high level, if I go from the very basics, but let me tell you, once the digital evidence is created, it cannot be deleted so easily. And therefore, under these circumstances, we found even Google could not provide the information to us, but still we were successful in recovering the deleted mails and hand over the case, which was a 450 crore rupees fraud. Well, very shortly you will be seeing this matter, because probably this will be one of the first case of its kind where we just completed the investigation just about a week before. And when I was talking to Dr. Deepak just about 3 or 4 days before, I said that, okay, let me talk something which is happening in the present time and not which has happened in the past. And this is something which is very significantly what I wanted to explain or to express to you, that how the recovery of the emails proved that company A should be accused and not the company B, even though all the indications by the law enforcement agencies were proven that company B was wrong and company A was correct. Well, therefore, it was alleged that company B and its representative had fraudulently accessed and deleted the emails. However, police were unable to locate the deleted emails and filed a summary B report against the company A. And the last point before I take an exit from here, and that's what I want to bring to all of your notice. Let me tell you, no private forensic report is appreciated by the court. In fact, there are a lot of agencies, who give their report, no private agencies. We have a provision in the Information Technology Act, Section 79A of the Information Technology Act, which says that report which comes only from the electronic examiner is found to be appreciated by the court. So, XYZ, any forensic private institute or an organization, when they make a report in a criminal case, is not appreciated by the court. And let me tell you, in this case, there were some certain reports which were made by some private forensic agencies also. And because they don't come in the gamut of Section 79A of the Information Technology Act 2000, therefore, their reports are not only admissible, but they are far from getting appreciated in the court of law. And therefore, under these circumstances, ladies and gentlemen, let me also tell you that when you have any type of a data fraud taking place in your organization, please don't waste your time, effort and money by having it get or having vetting your report for a criminal case from a private institute. That report has to come only from the government organization. And finally, India has only 7 labs. Only 7 labs India has, which are the electronic examiner labs. I am in Delhi at this moment. I come from Maharashtra. In Maharashtra, we don't have any lab yet as an electronic examiner lab. Yet. Yet means I landed in Delhi at 10 a.m. But Delhi has, Gujarat has, Karnataka has, Telangana has. There's one more lab which has come, Dharamshala, you know, I think Himachal Pradesh or somewhere. Yes, that has. But then the other states which are having the state-run cyber forensic labs, they are still not an electronic examiner lab. So therefore, I think, ladies and gentlemen, let me not criticize it, but let me bring the facts in front of you that when Google also raised its hands off, we were able to retrieve and present the report in the court. It should not happen to you, but if it does happen to you in your organization, I think the best step, as what the theme of this whole conference is, protection, prevention and securing the data from unauthorized practices by following a proper compliance is the need of the hour. Therefore, ladies and gentlemen, I take a leave from you, and I hope that I gave a liner for you in terms of the investigation and in terms that how an email costed a company almost 450 crores. And that's why it may be one email or 2 emails, that doesn't make a difference. But then even if one single email deletion, we found more than 400 emails which are found to be deleted, that's a separate part of the story. But even if one email also is deleted, it can be worth 450 crore rupees. Thank you very much, and thank you, Dr. Deepak, for giving me an opportunity to talk at this forum. Thank you very much.